about 2 weeks ago. And the commissioners will determine what to focus on, maybe more on the jurisprudence and other legal matters. We will introduce ourselves once again to you, Your Honor, and I will start with our acting CJ. The technical people, we need the microphones to work. AG, is yours working? We can start from your side. And then we'll come round as they fix that one. Frida.
Thank you, Madam Chair. Good morning, Judge. Kehara Kariuki, the Attorney General.
Morning, my lord.
Morning, sir.
Mohamed Warsame, welcome once again, my lord.
It's a big pleasure all the time.
Good morning, Judge.
Morning, sir.
My name is Felix Koske, representing the public. Welcome.
We thank you.
Good morning, my lord. My name is Machari Njagi. I represent the Law Society of Kenya.
It's a big pleasure, good Commissioner.
Good morning, my lord.
Good morning.
I am still Philomena Mbete Muilu. I represent the Supreme Court here. I'm the Deputy Chief Justice of the Republic of Kenya.
We thank you.
Good morning, Judge.
Good morning, sir.
I'm Pat Kishoi. I represent public service. Karibu.
Asante.
Good morning. David Majanja, Judge of the High Court, representing Kenya Magistrates and Judges Association.
A big pleasure, sir.
Good morning, my lord.
Good morning.
I'm Oluwande Evelyn, Chief Magistrate representing KMJ.
We thank you.
My lord, I'm Olive Mugenda, Commissioner representing the public and chairing these interviews. And we also are supported by our CRJ, Honorable Anne Amadi.
Good morning, Judge. Good morning.
And also by the Registrar of Judiciary of JSC, Honorable Frida Mokaya.
Okay. A big pleasure to you all.
So, Judge, will start with the interviews now, but I have one observation to make. The fact that we have received the letter where you have submitted the documents that were missing last time. The wealth declaration, now you have completed it, and the bank statement. Your Honor, I also noted that we have now a new copy of the disability card, which, as you said, it was an error and it has been corrected. So I just wanted to make that observation, and I don't know whether you have the original or we go by this copy.
I do have the original. It is available with me.
Thank you very much, Judge. So those forms are now with us, and we want to thank you for that effort.
Thank you.
So I'll start off by asking one question, Honorable Judge. If you join the Supreme Court, where there will be other colleagues, working with you, and so far, Your Honor, you have been your own boss, making your own decisions and have, enjoying your independence. So please give us 3 differentiating attributes that you are going to take to that court. Because we all have our own strengths. What is this that is unique, Honorable Judge, that you are going to take to that Supreme Court?
To the Supreme Court, I'll bring in collegiality, in a personal manner. I am a peacemaker. I am able to deal with public relations so finely. I make peace with everybody and anybody. That is what I would take to the Supreme Court firstly. to enhance collegiality, to enhance team spirit, to enhance what we may require in the Supreme Court to be able to be effective and play our role, our constitutional role as stipulated. The second one, which I would take there, is my exposure and experience from day one and 16th of October 1980 to date, well over 40 years. We've been in this game, the game of the law, and we've learned the ropes. So you will not be able to say that, or we cannot say that because you've been your own boss, etc., you are not superb or fit for this kind of a position. When you have the know-how, when you have the exposure, we've been to the House of Lords, we've been everywhere in the common law and the Commonwealth. We've been in Kenya, we've done East Africa. We are familiar with this game, and there is nothing which would make us any poorer in dealing with the issue. We also have our own good attributes. Like I said last time, I'm a superb leader. It is demonstrated all over my life. I give, notable examples of my leadership capacity. I've not been working alone, and it is not possible to work alone. So this is what we would carry to the Supreme Court to enhance its efficacy in constitutionalizing constitutionalism. Thank you.
Thank you, Judge, for that answer. Your Honor, there's some theories that suggest that for you to get to achieve your deliverables or your goals, that you need maybe 70-80% emotional intelligence and maybe 30%, 20% of IQ. Do you believe in this view?
So much so. It is the rule of the world. It is a universal truism that so much is not done on by virtue of your strength or intelligence. Those are just side issues. What you require is the element of a relationship that carries the better part of your projections, the better part of your achievements, etc. We are saying this because you may have everything that you may require in terms of IQ, etc. But this is not going to work for you if you don't have the wherewithal of emotional intelligence, if you cannot relate, if you cannot be able to differentiate what is workable and what is not workable, if you are not able to deal with everybody with a view to achieving any collective results, that way your brain, your intellectuality, your all becomes not very useful to humankind. Therefore, this is a daily practice, something you must keep on learning to do every day of your life so that you become useful. Minus that, you'll be on your own and you won't make any contribution whatsoever to anybody. Thank you.
Thank you, Your Honor. My last question, Your Honor, is in every group, even in the Supreme Court where you go, there'll be the leader. Your leader will be the president of the Supreme Court. But also in all the groups, there emerges other leaders who are not there because, by virtue of their positions, but they're just natural leaders in that group. So my question to you, Judge, is that do you see yourselves emerging as another leader, maybe in an area where you are very strong in, or are you just going to, to follow what your boss says? And if you're going to emerge as another leader, which area do you think you can come out strongly as a leader, despite the fact that you'll be having your president in the same court?
Thank you, Chair. I'll clearly and undoubtedly emerge as a leader because this has been demonstrated. Organizational skills is my hallmark. Last time we were here, I told you that I'm a very organized person. I am a very timeous person. I get things done and on the dot. This may be boring to many other people. You don't necessarily have to get them into it by force, but you can buy them into it. You can teach them the game. So organizational skills, industry are my hallmarks. And this is demonstrated all over from day 1 to 61 years and 4 months. That is what I'm going to sell to the Supreme Court of Kenya. I'm not confrontational. We shall have our natural leader, the President of the Supreme Court of Kenya, the Deputy President of the Supreme Court of Kenya, and the other group of 7, and it is proposed 9, maybe in the future, will come up with a different leadership quotients and serve the court, and serve Kenya, and serve humankind. Thank you.
Thank you very much, Your Honor. I will now request Acting CJ to continue with the questions.
Thank you. My Lord, let us start at the point of amicus curiae and interested parties. If my Lord would please tell us how the court, my Lord, wishes to join, has handled those 2 issues.
Traditionally, good acting CJ and Commissioner, amicus curiae was a friend of the court. That is a customary position. This has developed with time, and it has even gotten very complex, in the sense that we have had to develop other avenues in which to accommodate amicus curiae. In interested party, the differential between amicus curiae and the interested party is that the interested party has a direct interest in the matter which is being heard. Let me go back to amicus curiae. What has changed of late is that we found the situations, and we will be forced to address these situations in the future, where people do not necessarily come to court as amicus curiae to pursue that unilateral, that area where they are just friends of the court and impartial. We've noted more often than not that these people may come on that note, but in the course of time, they become even parties to the suit. So we may have to, in the future, develop strategies of dealing with that, because where, like is in the international foreign practice, we even have amicus curiae who may have some interest in the matter. Amicus curiae who clearly do not have any interest in the matter. The categorization of amicus curiae must now be developed in this in our jurisdiction, so that we are able to manage that in an effective manner without hiding faces or playing behind. Interested?
No. Let's stay with the amicus curiae first.
Yes.
And the question, my Lord, is to tell us what the court, what your dream court has already done, because it has, in a number of cases, defined the status of the amicus curiae and how one is to approach the court.
The court has set out precedent to the extent which amicus curiae would come out. This is by bringing a 6-point amicus curiae forum. And this is what I was referring to, like moving from the traditional amicus curiae, where you are merely a friend of the court. We brought out issues where people who have some interest of whatever nature may come in as amicus curiae. We brought in areas where people who have no interest whatsoever may come in as amicus curiae. We brought up other issues where we brought in a situation where other parties who have tangible issues on that subject matter may want to come in as amicus curiae. We may have other situations where groups or interested parties may want to come in as not as individuals but as a group to raise issues which add on to the subject matter and assist in its formulation. Those are the few examples I can remember.
Okay.
There are quite a number.
Okay. Does my lord remember any Supreme Court case that has specifically dealt with the amicus curiae?
I have read this generally. I cannot specifically point out any authority.
Is there a distinction between, my lord, the amicus curiae and interested party?
The distinction is very, very clear.
Mm-hmm.
In interested party, this person has direct or even indirect interest in the matter. The outcome of the matter will directly involve him, or directly or indirectly involve him. So he's not coming in, he's not even borrowing from the traditional amicus curiae where you're a friend of the court. He's coming in to pursue his interests, which may be direct or indirect. That is the difference.
Any case that comes to mind, my lord, by the Supreme Court on...
Again, on that one, I falter.
Thank you, my lord.
Please.
You would say, or would you not, that the Supreme Court is not busy, would you?
No, the Supreme Court is very, very busy.
Good.
Very busy to the extent that it is even backlogged, which is very, very unfortunate. That's a place, if you ask me, where we should be free of a backlog. And I'll be dealing with matters within a month, 2 or 3, when that is practical and possible. The Supreme Court is busy to answer your question.
Do you know, my lord, the extent of that so-called backlog?
It is about 200 and, did I read 235 cases? It's between 100 and 250 cases, if I read right.
My lord, that backlog in the Supreme Court? Let's stay there. And please, my lord, tell us what in
that
your
could be
view,
the number of due cases. Please ask your question.
I already asked part 1, but let me ask part 2. Whatever the backlog could be, might my lord know the reasons leading to that backlog?
Yes. One is incapacity. One of the biggest issues we have in the Supreme Court is incapacity. There are 7 judges. Of these 7 judges, one is the Chief Justice. The other one is the Deputy Chief Justice. At all times, one of the judges would have to appear in the JSC, or Judicial Service Commission, as a representative of the Supreme Court. We have issues of incapacity. People, the judges, one of the judges may not be available for 1 or 2 reasons. Ailment, being away for good measure. So one of the basic reasons why we have this backlog is because of the issue of the quorum for the Supreme Court. The quorum is 5 judges in open matters. The quorum is 2 judges in interlocutory matters, applications. So the possibility of not having a quorum in this situation is very, very high. For example, now the Supreme Court does not have two judges, the Chief Justice and the Judge of the Supreme Court. They are not available. Should anything happen to any of the other judges, it will not be possible to convene a quorum. Should, in a situation like this one, where her leadership is appearing at the JSC for this very, very important matter, the Supreme Court cannot sit, and that is the dilemma.
And therefore, my lord, clearly you have read our strategic plan, and you have seen that we have identified that as a big problem, what would your remedies be?
The suggested remedy in the strategic plan is that the Supreme Court be raised constitutionally to 9 judges. I had all my life wanted to fight that. But recently when I looked at that and the rationalization of the strategic plan for the Supreme Court, it brought me to senses. It makes a lot of sense. The situation we have now is impractical, if not impossible. It's a do or die situation. This is a very, very, very sensible, proposal that the Supreme Court firstly be improved by 2 other members or 2 other judges, and maybe in the future we can even move up to 11, depending on the constituency.
Thank you, my lord. One of the objectives for the court is to provide authoritative and impartial interpretation of the Constitution. You have also, my lord, heard, and please tell us where you heard it, this statement, constitutions without constitutionalism. With that in mind, would my lord debate the particular objective of the court that I have just stated, my lord?
Thank you. Constitutions without constitutionalism is the catchphrase emanating from a write-up by my good friend and teacher, Professor H.W.O. Okoth Ogendo, late of Njagi, most likely Kisumu County. He wrote this material a while ago, and everybody who imagines that he wants to be a constitutional lawyer or is a constitutional lawyer would have to identify with that. It's an international material. Relating this now to the Supreme Court of Kenya, which constitutionally is intended to be the master of the master interpreter of the Constitution, the impartial interpreter of the Constitution, the impartial practicator of the Constitution, in the sense that this interpretation must also be brought out in terms of, must be practical. Impartial, we are not even beginning, but it must be impractical. It must be practical. The Supreme Court has done very, very, very well on this. It has brought itself out on so many aspects of our Constitution in terms of opinions, in terms of case law, in terms of advisory opinions, case law, and so far we would not want to complain. Well, there may be issues which we may further have to debate, like the position of the Constitution, the position of the Supreme Court insofar as election petitions is concerned, but you look at that jurisprudence, it is apt, it is to the point. What we may require in the future is now compare notes with the outside world and see whether we can come in and bring out the small issues and come out clean. So far, so good for the Supreme Court.
Thank you, my lord. I do not remember what my lord said about the issue of writing joint or individual judgments in the court at your last interview. Maybe you could remind me if it was asked of you, and if it wasn't, could my lord please tell us what your position would be on writing individual and or composite judgments?
Thank you, good Commissioner. This was not raised with me last time. I cannot remember. The 9 days ago, it was not raised with me. But my answer to this would be, I have read, I have looked at the decisions of the Supreme Court in both the majority decisions and the dissenting decisions in one or two cases. I have also read the concurring decisions of the Supreme Court. In the matter for Munya, the Chief Justice wrote a